off the record, the state has tendered case law to Your Honor and discussed legal principles. I think that these are decisions that would be important, or discussions that would be important for the Court of Appeals.
And the state gave Rogers versus State, and that's the Court of Criminal Appeals.
Rogers versus State, 105 Southwest 3rd, 630 from 2003. Your Honor, we've cited you authority in our proposed instruction where the proposed language we provided was given and has been approved of. It is an instruction on voluntariness, which is a statutory requirement in the Texas Penal Code. The language does use the word accident, but it is used in an explanatory fashion and not as a legal term of art. And that instruction has been approved of. The issue, again, is this.
Give me a second. I'm going to... While you're writing, I'm going to get this proposed instructions up to Abbas. They can start making some changes to the jury instructions while you're listening to this. Wasting time.
Thank you, Judge. Okay. The issue is this. Mens rea and intent are going to go to the act itself. The act itself is a kick. And I think it is certainly within that room for there to be a contention while the action itself was intended. It was not an unintended action or an involuntary reflex. That the force applied in the action could very well still have an involuntary component. And that would be consistent with the testimony that we've heard. That you have an intention to kick, but you don't have an intention to kick with such force that it would cause someone's death. Or you don't have, you don't voluntarily allow the foot to land in a place where it would be able to, land with people.
That's more on manslaughter. He's not saying I tried to kick, the chair in the restroom to scare her and I accidentally kicked her. He's saying I kicked her.
I guess what we're saying in layman's terms would be I intended to use proportionate force to stop an attack. I was justified in using that force. And in the course of using that justified force,
is this on, where is it? What's on 601? Is that?
It's the voluntariness language of the Penal Code.
Okay. And that's where you're getting at?
Right. That's the statute that we believe authorizes the instruction. And the language that we're using in the instruction comes from the case that we cited.
And I'll hear from you again, but let me hear the state now since it's on the record too, and I'm going to make a decision, and obviously for any higher court to look at it. Go ahead.
What did you want from?
You're on the record with your arguments you were making earlier.
Sure. We're just objecting to the. You want me to make both of my objections, Your Honor?
Sorry.
Do you want me to make both of my objections to both of the proposed?
That's fine.
So just for the record, the state is objecting to the 3823 instruction in that there has been no material fact that is contested that's been on the record. Deputy Lozano testified directly that he had no knowledge of the broken garage until he pulled up, and there's been nothing that the jury has heard that disputes that. There's been arguments, there's been assumptions by the defense, questions from cross-examination, but there's been no direct evidence that Deputy Lozano had any knowledge prior to that broken garage when he pulled up. So that's what we're saying for the 3823 should not come in. And the voluntariness, we are objecting to that. In their proposed charge, two things. They are saying use the word accident. In the case that the state gave the court, clearly says that there is no defense of accident in Texas, right? And voluntariness very much is about the conduct at the time. There has been no suggestion that Mr. McDonald did not have full control over his actions at the time when he kicked her twice. Your Honor will remember the description of the kick, and we just think that there's no way without that they are entitled to a voluntariness instruction.
Your Honor, lastly on the issue of voluntariness, the Rogers case that was cited discusses the idea that if there is physical movement that is non-volitional as the result of someone else's action or set in motion independent, non-human force.
Like a convulsion or unconsciousness, hypnosis, something like
It
that?
certainly could be, but it can also be, for example, there's a case where there's a fight between three people, and the facts were that one of the individuals was trying to commit suicide, and the other person was trying to get the gun away, and the gun goes off. That could be a voluntariness issue. But in this case, I think because what we're talking about is a charge, grappling with the person attacking him, using their momentum against them to bring them to the ground, and in the same motion kicking them, which is the description Mr. McDonald gave on the stand. We have to consider...
He was doing self-defense, but he wasn't voluntarily doing it?
No, Your Honor, we're not saying that. But what I'm suggesting to you is, look, our position is and remains that Mr. McDonald countered lethal force with lethal force justified and in proportion to what was being attacked against him. That is our position. However, I think that there is a more granular way of looking at the narrative that allows us to consider that Mr. McDonald is justified in the use of non-lethal force in at least two different moments in the course of this scuffle, and that his response, by all objective measurements, was to provide proportionate non-lethal force. And yet we have a death. And so the problem we run into is that there's going to be a tendency on the part of the jury or any trier of fact to look at that and say, well, irrespective of your discussion of it is non-lethal, irrespective of what we generally understand, that kicking someone is not generally expected to be a lethal act, we have a death. And so it's now lethal force. How do we bridge that gap? How does the statutory language bridge that gap? I think that clearly one of the ways that the statutory language bridges the gap is that when someone does not know their own strength, or that is not an objective of theirs as to where the kick is going to land exactly, or the kick is being delivered in the course of a martial art maneuver that is using the other person's momentum against them, that we have factors that are beyond the individual's control and beyond the individual's volition, and the voluntariness instruction would help ensure that that application of self-defense is also on the table for the jury. That's why I think it's important. We're not saying that he didn't intend to kick her. We're not saying that it was involuntary to kick her. We're not saying it's like someone, tapped his knee at the doctor's office. But we are saying that there is a non-volitional component in any situation where someone is justly and aptly using non-lethal force, but death nevertheless arises, especially in situations whereas here there's ways to interpret this testimony that the kick landed in a particularly sensitive area where soft tissue was damaged, or where the amount of force that was received was just simply more than anticipated, more than the defendant was trying to deliver. Those are issues that I think voluntariness goes to the heart of. And the fact that most cases are not so granularly broken down, we don't have such snapshot opportunities to judge and evaluate the justification at each step of the fight, doesn't change the fact that this case does provide those opportunities. Most people that want this instruction, all they can say about it is, I didn't mean to kill him. And that isn't sufficient.
Any brief follow-up? Did you file this morning?
We filed it yesterday.
Yesterday, okay, yeah, because I said yesterday was a deadline. I got the states, but not yours. That's why
Your Honor, also, if I can, just briefly respond to the questions about the 3823 instruction. The state has said that there's no evidence of a genuinely contested issue of material fact, but they acknowledge that part of the evidence...
This is Deputy Lozano, that's all we're talking about, right?
Yes.
The garage issue.
And the garage issue. In their recitation of how we put this argument before the court, they mentioned cross-examination. The testimony elicited on cross-examination is competent evidence. It's perfectly sufficient to raise an issue in a jury instruction. There is evidence. And here's what I believe the evidence has developed. What we know is that on March 1st, until the wee hours of the morning, the Bexar County Sheriff's Office was parading through Andre McDonald's home and treating it as a crime scene. You've heard testimony both at the motion to suppress and at the trial that individuals believed it was a crime scene, that they believed when they saw the blood on the light switch that Andreen was dead, that they believed that this was a homicide investigation, but they were obviously still considering it a missing persons case. You have the surrender of the scene back over to Mr. McDonald that evening of March 1st or in the early hours of March 2nd. The next morning, we have gate codes that the state has admitted, which show that Andre McDonald came back to his residence in the late portion of the 11 o'clock hour in the morning. We also know from those gate codes that there were Bexar County Sheriff's officers in the community 10 or 15 minutes before Andre McDonald's arrival. We know that board, who the state has not called, despite it being their burden on this issue because it is a warrantless intrusion into the home, was surveilling Andre McDonald from his driveway. In other words, watched him leave his house that morning when he drove off to go to Nagel's gun store. We know that Lozano's unit is a sort of community outreach unit, not normally engaged in patrol, not normally engaged even in issues specific to responding to houses. They do anything from perhaps go check on somebody who's asleep at the bus stop to maybe doing a welfare check at a house, but also doing things like helping set up for an event that the sheriff's office is hosting. He's stationed over off of Highway 90, Marbach. He's coming around all the way to Stone Oak for a random call. He reports to a outpost unit set up for the Andreen McDonald case. He's given orders, he can't say from who, that he needs to go check on this house.
So what's the factor here? You're just still trying to say that he knew that the arrest happened first at Nagel's and then they went after?
What I'm saying is, as a matter of law, what he knows individually is not the end of the question. The goal here is, it's the collective knowledge of law enforcement that is at issue in any particular question of probable cause or justification for warrantless entry. And without question, the collective knowledge of law enforcement would have known all the things that this court has heard testimony of, up to and prior to the time that Deputy Lozano makes entry into the house. We know that Board was surveilling McDonald as he left the residence, which means that Board was there. We know that a BCSO car, which I think we could safely infer was Board's, at least there's enough evidence where that is one inference that could be drawn, arrived before Andre McDonald returned home and before the garage door was damaged. We know essentially when the garage door was damaged based on Chedlad's testimony. It would have happened sometime between 12:45 and 12:50 in the morning, I believe. Knowing all of that, we know that the collective knowledge of the Bexar County Sheriff's Office was that everyone understood that that garage door was damaged by Andre McDonald making a boneheaded mistake backing out of his garage that morning, and that it was not evidence of burglary, forced entry, or some other massive, crazy change of circumstance that would justify this. All of that would have been known, and that has been established by the testimony. That is not my argument. That is not my conjecture. It's not, as the state characterized it in its email, a conspiracy theory. Those are just the facts that have been adduced and that have not been rebutted. The state would have called Board to have cleared this up in a heartbeat.
Right, I'm going to stop you there. I'm going to give you that instruction of 3823, but I'm going to tweak it a little, and then let me take a look at this accident voluntariness. Said I wasn't going to give it, but I'm still, since I just got your thing this morning, I'm looking at the code. Let me decide on that. That should be pretty soon, okay?
Thank you, Judge.
And any rebuttal witnesses that y'all said y'all were thinking about calling?
No, we have one, Judge, yes.
And it depends on what they say. Witness, if you have any?
Yes, Your Honor.
Okay. Well, let me try to get this ready for y'all and bring it up, and then y'all can still put your objections on the record, but let me get it ready now.
And Judge, are you entertaining our request to do an application, since you're including the 3823, to actually apply the law to the facts that the jury is looking at?
On the 3823, the March 2nd, right?
Correct.
Since I'm giving it.
So some sort of application that the jury's applying the law to the actions.
That they know that the emergency
on.
doctrine, I think that's reasonable. Yeah.
We've given an application paragraph that applies the law specifically to the facts. We would ask the court to use our proposed language for that application paragraph.
Okay, I think it's the one they sent up right now. Okay. All right, let me give y'all something. I'll be back in a minute.
Judge, I would think maybe it would take 15 at the most. Probably closer to 10.
how much time are each side asking for closing arguments?
Judge, I'd probably request maybe 45 minutes. I think we would give time to act, but just to be on the safe side.
Defense, 45, good?
I think we can make that work, Judge.
Okay. Okay, that helps out a little. So, he's going to be getting his charge at hopefully 10:30, 10:45, and they'll stop around 10:45 would be like 12:15, 12:30. Okay. Yeah, have a seat, thank you. All right, let's bring that rebuttal witness out first. No, I'm sorry, the witness, get the jury in for the witness.
Your Honor, before the jury comes in, with respect to the rebuttal witness, it's my understanding that the rebuttal witness is Sergio Perez, who is the gentleman in Brownsville that...
Who is he?
He's the gentleman in Brownsville that Mr. McDonald went to visit with Andreen in the summer of 2018. We would object that it's improper rebuttal, that it is basically to give a timeline of where we ended up here. The state called Andreen's father to the stand before we adjourned for the storm, and over our objection testified to what we believe was an improper 404B analysis. And that testimony was admitted, especially compounded by the fact that the state advised that it was going to be a general or reputation-based opinion on character for violence or law-abiding behavior, and then by the nature of the question elicited a specific instance of conduct that would be admissible under 404B. That necessitated us having to elicit testimony from Mr. McDonald on the stand about that event. And now the state is calling rebuttal to address Mr. McDonald's testimony in response to that event. So we think that under 404B, the same objections that necessitated not receiving that testimony from Andreen's father should be applied to this, and that it's therefore improper rebuttal.
Clear response?
Your Honor, earlier the testimony that was entered was under 3836, under 404B as defense tries to assert. Oh, of course.
What are you trying to rebut?
Your Honor, the defendant testified about the situation on July 4th of 2018, about his actions as well as the victim's actions, as well as who was actually there at the time. The state is calling Mr. Perez to rebut what the defendant testified to here on Monday as to those aspects.
They caused the
hold on, I think my rulings were fine earlier, allowing it in, but this rebuttal is getting too far. The jury's here to hear about this case, and I'm going to go ahead and grant your to not allow that witness to rebuttal. Okay, y'all want to approach, come up, get the jury charged?
Yes.
But I took out the word accident. That's pretty much everything else, but not accident. It's on the voluntary. Let me see if I can find what page it's at.
Thank you. You may be seated.
Morning, ladies and gentlemen. Sorry about the delay. State, any other witnesses arrested and closed?
The state will close.
Okay, defense arrested and closed?
Rest and close.
Okay. All right, ladies and gentlemen, at this time I'm going to read you the charge of the court. Please listen carefully. You will get a copy of this when you go back to the jury room for your deliberations. After I read this charge, attorneys will make their closing arguments. Okay, members of the jury, the defendant, Andre McDonald, stands charged by indictment with the offense of murder alleged to have been committed on or about the 28th day of February 2019 in Bexar County, Texas. The defendant has pleaded not guilty. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Individual means a human being who is alive. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss of impairment of the function of any bodily member or organ. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. You're instructed that a person commits an offense only if he voluntarily engages in conduct, including an act, omission, or possession. Conduct is not rendered involuntarily merely because the person did not intend the results of his conduct. Therefore, if you believe from the evidence beyond a reasonable doubt that on the occasion in question the defendant, Andre McDonald, did cause the death of Andreen McDonald by kicking her or by a manner and means unknown to the grand jury as charged in the indictment, but you further believe from the evidence, or you have reasonable doubt thereof, that the act of kicking Andreen McDonald or the manner and means unknown to the grand jury as charged in the indictment was not a result of voluntary act or voluntary conduct of Andre McDonald, you will acquit the defendant and say by your verdict not guilty. You're instructed that it is a defense to the prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another if the person would be justified in using force against the other in the first place, as set out above, and when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. The use of force against another is not justified in response to verbal provocation alone. A person has a right to defend from apparent danger to the same extent as he would had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him from his standpoint at that time, or at the time. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. So please turn the phones off. Okay, deadly force means a force that is intended or known by a person using it to cause, or in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition including death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person who has the right to be present at the location where the deadly force is used and who has not provoked the person against whom the deadly force is used and who is not engaged in criminal activity at the time of the deadly force is used is not required to retreat before using deadly force. If all three of these factors are met, then in determining whether such actor reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. The defendant is not required to prove self-defense. The state must prove beyond a reasonable doubt that the defendant's conduct was not justified by self-defense. Now, if you find unanimously from the evidence beyond a reasonable doubt that on or about the 28th day of February 2019 in Bexar County, Texas, the defendant, Andre McDonald, did intentionally or knowingly cause the death of an individual, namely Andreen McDonald, by a manner and means unknown to the grand jury, or the defendant, Andre McDonald, with intent to cause serious bodily injury to an individual, namely Andreen McDonald, did commit an act clearly dangerous to human life that caused the death of Andreen McDonald by a manner and means unknown to the grand jury, Then you will next consider whether the defendant acted in self-defense to the charge of murder and proceed to paragraph 6. But if you do not so believe, or if you have reasonable doubt thereof, you will acquit the defendant of the offense of murder as charged in the indictment, say by your verdict not guilty of the charged offense of murder, and proceed to paragraph 7 to consider whether the defendant is guilty of the offense of manslaughter, which is a lesser included offense of murder. Now, keeping in mind the general instructions on self-defense given in paragraph 4, even if you unanimously find the state has proven beyond a reasonable doubt that the defendant, Andre McDonald, committed the charged offense of murder, you must next decide whether the state has proven beyond a reasonable doubt that the conduct was not justified by self-defense. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Andre McDonald, committed the offense of murder as charged in the indictment and is instructed in paragraph 5, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, Andre McDonald reasonably believed, as viewed from his standpoint, that Andreen McDonald was using or attempting to use unlawful deadly force against Andre McDonald, and Andre McDonald reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Andreen McDonald's use or attempted use of unlawful deadly force, and Andre McDonald's use of deadly force was not in response to verbal provocation alone, then you will acquit the defendant of the charged offense of murder and say by your verdict not guilty, and do not consider manslaughter as a lesser included offense as instructed in paragraphs 7 through 9. However, if you find from the evidence beyond a reasonable doubt that the defendant, Andre McDonald, committed the offense of murder as charged in the indictment as instructed in paragraph 5, and you further find from the evidence beyond a reasonable doubt that Andre McDonald did not reasonably believe, as viewed from his standpoint, that Andreen McDonald was using or attempting to use unlawful deadly force against Andre McDonald, or Andre McDonald did not reasonably believe, as viewed from his standpoint, that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Andreen McDonald's use or attempted use of unlawful deadly force, or Andre McDonald's use of deadly force was in response to verbal provocation alone, then you will find the defendant, Andre McDonald, guilty of the offense of murder as charged in the indictment, and do not consider manslaughter as lesser included offense as instructed in paragraphs 7 through 9. Our law provides that a person commits the offense of manslaughter if he recklessly causes the death of an individual. For the offense of manslaughter, a person acts recklessly or is reckless with respect to the result of his conduct when he is aware but consciously disregards the substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 28th day of February 2019 in Bexar County, Texas, the defendant, Andre McDonald, did recklessly cause the death of an individual, namely Andreen McDonald, by kicking her with his foot or by a manner and means unknown to the grand jury, then you will next consider whether Andre McDonald acted in self-defense and proceed to paragraph 9. If you do not so find from the evidence beyond a reasonable doubt, or if you have reasonable doubt thereof, you will find the defendant not guilty of the offense of manslaughter and do not consider paragraph 9. Now, keeping in mind the general instructions on self-defense given in paragraph 4, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Andre McDonald, committed the offense of manslaughter, you must next disregard whether the state has proven beyond a reasonable doubt that the conduct was not justified by self-defense. Therefore, if you have to find from the evidence beyond a reasonable doubt that the defendant, Andre McDonald, committed the offense of manslaughter as instructed in paragraph 8, but you further find from the evidence that you have a reasonable doubt as to whether at the time he did so, Andre McDonald reasonably believed, as viewed from his standpoint, that Andreen McDonald was using or attempting to use unlawful deadly force against Andre McDonald, and Andre McDonald reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Andreen McDonald's use or attempted use of unlawful deadly force, and Andre McDonald's use of deadly force was not in response to verbal provocation alone. Then you will acquit the defendant of the offense of manslaughter and say by your verdict not guilty of manslaughter. However, if you find from the evidence beyond a reasonable doubt that the defendant, Andre McDonald, committed the offense of manslaughter as instructed in paragraph 8, and you further find from the evidence beyond a reasonable doubt that Andre McDonald did not reasonably believe, as viewed from his standpoint, that Andreen McDonald was using or attempting to use unlawful deadly force against Andre McDonald, or Andre McDonald did not reasonably believe, as viewed from his standpoint, that the use of deadly force and degree of deadly force used is immediately necessary to protect himself against Andre McDonald's use or attempted use of unlawful deadly force, or Andre McDonald's use of deadly force was in response to verbal provocation alone. Then you will find the defendant, Andre McDonald, guilty of the offense of manslaughter. In this case, the evidence has been introduced to the effect that the defendant may have previously committed acts of misconduct or offenses other than for which he is now on trial. You are instructed that you cannot consider said testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such acts of misconduct if any were committed. If you so believe, you may consider the same in determining the motive, opportunity, intent, preparation, plan, knowledge, and or consciousness of guilt, if any, of the defendant in this case, or to assist you, if it does, in determining the context of the offense committed in this case, if any was committed, and or to rebut a defensive theory, if it does, or to aid you, if it does, in passing on the credibility of the defendant as a witness in his own behalf and the weight to be given his testimony. You may consider such evidence for such purposes and no other. You are instructed that under our law, no evidence obtained by an officer or person in violation of any provisions of the Constitution, of the laws of the state of Texas, or the Constitution or laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. The Fourth Amendment of the United States Constitution states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. A search conducted without a warrant is issued upon probable cause is per se unreasonable, subject only to a few specifically established and well delineated exceptions. One of those exceptions is the emergency and aid doctrine. The Fourth Amendment does not bar police officers from making warrantless entries and to assist persons who are seriously injured or threatened with serious injury. The need to protect or preserve life or avoid serious injury is justification for what would otherwise be unlawful. Under the emergency aid doctrine exception to the warrant requirement, a warrantless search of a person's residence is allowed if an objectively reasonable person, considering the facts and circumstances known to the police officer at the time, would enter to protect or preserve the life or avoid serious injury. The exception does not apply if the officer was primarily motivated by his obligation to investigate criminal activity. Therefore, if you believe that or you have reasonable doubt as to whether any evidence obtained offered into evidence was obtained in violation of any provisions of the Constitution or the laws of the state of Texas or the Constitution or the laws of the United States of America, the jury shall disregard any such evidence so obtained. Specifically, if you find from the evidence that Deputy Lozano's entry into 1042 Solitude Cove on the morning of March 2nd, 2019 was not justified under the emergency aid exception to the warrant requirement, or if you have reasonable doubt thereof, you will disregard any and all evidence obtained as a result of the entry by the officer, and you will not consider such evidence for any purpose whatsoever. However, if you find from the evidence that Deputy Lozano's entry into 1042 Solitude Cove on the morning of March 2nd, 2019 was justified under the emergency aid exception to the warrant requirement, then you may consider the evidence obtained by Deputy Lozano and the officers as a result of their search on that day. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, computer, the internet or any internet service or any text or instant messaging service or any internet chat room, blog, website to include but not limited to Facebook, MySpace, LinkedIn, YouTube, Instagram, Google, Twitter, to communicate with anyone and any information or receive any information from anyone about this case or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for the purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number but are neither offered nor received in evidence. I can only send statements and reports received in evidence to the jury room. You're instructed that the statements of counsel made during the course of the trial or during argument, if not supported by the evidence, or statements of law made by counsel, if not in harmony with the law stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is a means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you have about any fact or person connected with this case which is not shown by the evidence. You're instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as a presiding juror. You're the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to the verdict, but jurors have a duty to consult each other and to deliberate with a view to reach a unanimous agreement, if that can be done without violence to individual judgment. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight of the or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of retaining a verdict. Returning. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require the defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms to your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Okay, your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any questions you may have. Instead, address the question to the court in writing. If you want to communicate with the court, notify the bailiff. Any communication relative to this case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. There's a verdict form for finding the defendant not guilty of murder and guilty of murder and not guilty of manslaughter and guilty of manslaughter. Okay, when you go back there, I'm sure you've already seen this. Read it again, but I believe it's one for a note, for a button to push. It'll notify us over here in the bailiff's for a verdict. If you do get a verdict in the foreperson, go ahead and sign this, put it in the verdict manila envelope form. Don't show it to anybody. If staff or deputies go back there to just check on you, it's not gonna be revealed until you come in here, hand it to my deputy, and he gives it to me for my inspection and announcement, okay? Each side's gonna have 45 minutes. Watch out. They say
For 133 days, a member of our community, Andreen McDonald, laid in a field off a Speck Road, waiting for her voice to be heard. Andreen McDonald was a mother. She was a daughter, a friend, a 29-year-old businesswoman. But she laid in a field, reduced to turning into bones. And it was all at the hands of a man who sits 20 feet from you guys. And just as Andreen wanted her voice to be heard, Andre McDonald wanted the opposite. Every step of his behavior from the time of Andreen's death was to deceive, was to cover up, was to fool everyone who was trying to find out what happened to Andreen. And that continued on Monday of this week. This man who every step of this attempted to cover this up wanted that voice to go silent. You saw it in those searches. He was hoping those bones would go away. And how he spoke about Andreen. The body. It was a hassle. I couldn't believe this happened to me. Andreen wasn't a hassle. She was a person just like you and us. And she deserves justice in this case. And she deserves justice for what this man did to her. Now, we spoke about in Boydire what can lead to domestic violence murder. And we talked about infidelity. We talked about money issues. We talked about maybe disagreements. And ladies and gentlemen, you've heard some things like that in this particular case. There's no doubt that Andreen McDonald may not have been perfect. Just like you and I. But I think it's clear that you guys understand that you're hearing one side of a two-sided story. And absolutely nothing that Andreen McDonald did deserved for her to end up in a field like she did back in 2019. And ladies and gentlemen, this is a case where you heard how Andre spoke about her. How the disrespect, how he had helped pay for her school. He was 10 years older than her. He believed that he owned her. He believed that he controlled her. And when he saw that slipping away, when Andre saw what he couldn't control, he crushed it. And that's a domestic violence murder. And it's a problem in our community that we all live in.
I'm going to object to the appeal to the community.
It's a little routine.
And that's a problem in the community that we live in. And the 12 of you here get to decide how to deal with it. Because that behavior, it's like a cancer. It's like a malignancy, a poison in our community. But as members of this jury, you 12 get to be the doctors to decide how do we handle this behavior. And we ask that you handle the behavior by holding him accountable for what he won't hold himself accountable for. Now, ladies and gentlemen, I'm going to speak to you a little bit about the law, and then the defense is going to make their argument, and then Steve is going to finish up our argument. Now, we, the jury, are asking you in no uncertain terms to hold him accountable for what he did, and you find him guilty of murder. And the law in this case, and the evidence applied to it, allows you to do that. Now, we spoke about in Boydire, there's two ways that we're talking about murder in this case, and one is intentionally or knowingly causing the death of another. And that one's pretty straightforward. And if you'll remember, then we went to, well, what if you didn't intend to cause the death? And I gave a slide about hitting someone in the head with a bat. It would be some loophole to do something dangerous like that and say, well, I didn't intend for her to die, right? So we have it a second way. Intend to cause serious bodily injury and you commit an act clearly dangerous to human life and you cause the death to another. So we have it two different ways. The first is intentionally or knowingly causing the death. The second paragraph is with intent to cause serious bodily injury, you commit an act clearly dangerous to human life that causes the death of Andreen in a manner unknown to the grand jury. Now, there's two paragraphs there. And the most important thing is you guys have to, each one of y'all has to agree on that you find one of the two guilty, or two of them guilty, beyond a reasonable doubt. Y'all don't all have to agree on the same one, just each of the 12 of y'all has to find one of those two ways guilty beyond a reasonable doubt. And if you remember in this case, we talked about what beyond a reasonable doubt is. You heard a ton of evidence. This is a murder case and a cover-up afterwards. Every step of Andre's behavior tells you that. He didn't want you guys to hold him accountable for what he did. That's the whole reason this cover-up started. Every step of his behavior, it wasn't panic, it was calculating. And that calculating nature continued to Monday of this week. He's guilty of murder beyond a reasonable doubt. Every piece of evidence and credible testimony points to this being a murder. Now, we heard the judge read about self-defense, and I'm going to talk to you guys a little bit about self-defense in this particular case. And the most important thing to realize is the only piece of evidence that tries to lay out any type of self-defense is Andre McDonald's self-serving story. Okay? If you disregard his self-serving story, there's no evidence of self-defense because self-defense didn't happen in this case. Now, let's just, for humoring purposes, let's go through. Because even under his story's facts, self-defense doesn't apply either. Now, when we talk about self-defense, I have it in a long paragraph here, but essentially we have 4 prongs here. When and to the degree he reasonably believes is immediately necessary to protect against unlawful force. When and to the degree he reasonably believes is immediately necessary to protect against unlawful force. Also, you can't use it in response to just words. It has to be unlawful force. And if you read it, it's not just because they did something that I disagree with. It's not to teach them a lesson. It's not because she disrespected me or said something that I didn't like. It's to protect against force. And there are even more requirements to kill someone in self-defense. And we all understand why that. We want there to be requirements to do something as serious and as permanent as killing someone. So in addition to all the things we just talked about, when and to the degree he reasonably believes the deadly force is immediately necessary to protect against unlawful deadly force coming back against him. Equal force with equal force. Not someone spit on me, not someone was running on me. And it's very difficult because you heard what his side of the story was. He's afraid of this superwoman that's so much bigger and stronger at him, yet in the 2 interactions they have, he headbutts her and opens her up. And then the second one, she's running at him and he does some type of judo move, gets her on the ground, does 2 kicks he doesn't know where, and suddenly she's dead. It's not reasonable. And his story is not reasonable. And that's why self-defense doesn't apply, because it's a murder case. Now, the law instructs you to deliberate on murder, and if you find him guilty of murder, you're done. If you disregard.
Is that a member of the media? I just want to make sure it's no one's getting the jurors. You remember the media? Okay, go ahead. It's not, if not, member of the media, put your phone down and nobody get the jurors. Go ahead.
Yeah, continue, Judge.
Yes.
So, Your Honor, this is an objection to this statement of the law. The charge instructs the jury that if they believe that he's guilty of murder, they need to next consider whether he's acted in self-defense, whether the elements have been met. Just triggers their obligation to consider self-defense.
I'll let him continue. You can make that your argument.
And that's what I just explained to you. If you give his story the credibility it deserves, self-defense does not apply. Now, in the charge it talks about if not guilty on murder, next you consider the offense of manslaughter. And manslaughter would look like this, and you'll have it in the charge. recklessly causing the death of Andre McDonald. And we have a definition for reckless. Recklessly causing the death doesn't make sense under any side of any story that we've heard. He wasn't recklessly kicking her. He wasn't recklessly doing any of these things. This is not a manslaughter case. I explained to you what it is, but I'll tell you in no uncertain terms that this is a murder case that Andre McDonald then covered up. Now, regarding evidence in this case, there's particular things that you guys are able to look at when you make your decision. Any testimony that came from the witness stand, any photos, the physical evidence, if you recall, the axe, the hammer, all these things that we were collected and that are sitting here in a pile, all the text messages and searches on the phone that Andre McDonald made. The videos of the extensive cover-up at the hospital. Remember when he was going and pretending he was going to the hospital to check on her when he knew she was laying in that field? All of these things are things that you consider as evidence in this case. One small thing, police reports and witness statements are not evidence. At times, you may have saw police officers or witnesses refer to their witness statements. It's the rules of evidence that don't allow those to go back with y'all. They're simply to refresh their memory, so those won't be part of the evidence you'll receive in this case. However, everything else you did, you saw, and you received into evidence will be. And the important thing to remember is that each one of y'all are the judges of the credibility of all the evidence and the witnesses, including Andre McDonald. This is an individual who every step of this case intended to deceive. He lied to people the day of it happened. He was lying to everyone. He was trying to cover up his tracks. He was trying to escape responsibility for this, and you give him that credibility because what he's told you is, yeah, I lied, yes, I deceived. Everything I did was a lie and a deception to get away with this, but now I'm telling the truth. Is it reasonable that he wouldn't still continue lying when he took that stand to get away with what he's been trying to get away with from the very first day? You are allowed to give that credibility that it's worth, and I'll tell you that it's self-serving. I think the most important thing to take from his testimony is the way he feels about Andreen. The body. You remember? The way he left her, said he left her naked in the field. That's a humanizing aspect. This is the mother of his child. Now, ladies and gentlemen, the facts in the law will be, you will apply the facts to the law, and in this case, the facts are murder. This is a murder case. Andre McDonald murdered his wife, Andreen McDonald. He took her and threw her in a field, and he had hoped that this day would never come. That her bones would go away, that no one would ever find this huge inconvenience that happened to him. But ladies and gentlemen, I believe that the day of responsibility for Andre McDonald has now come. And we heard that this is a trial of responsibility. But in this particular case, when someone won't take responsibility for what they've done, it's up to 12 brave members of our community to hold him responsible for what he did. That's the responsibility he deserves in this case. And we ask that you do that. And I'm going to sit down and then Steve will come up and follow our argument. Thank you.
You're going to have about 32 minutes remaining. Okay, defense, you have 45 minutes.
Thank you, Your Honor. Opposing counsel, may it please the court, ladies and gentlemen of the jury, I'm here just to talk to you a little bit more about the instructions, and then Mr. Combry is going to talk to you in more detail about the actual facts of this case. In particular, I want to talk to you about a part of the instructions that the state didn't spend a lot of time with, which is in Section 11, there's a lengthy discussion here about the Fourth Amendment. And I think that's an important factor in this case that should not be overlooked as you deliberate. This country puts the individual person above all other aspects of civic life. The individual is sacred. The individual is more important than the government, than the interests of the public at large, than any sense about what's going on in the community. The law protects the person first. And it does that through several different things. The first is, the instructions talk about this at length, the presumption of innocence. If we're going to have to take someone's liberty away from them, if we're going to have to intervene in the ordinary course of their life for the greater public good, we have to make sure that we're doing it right, that we're strictly trying to assume them innocent in all possible opportunity, that we give them the benefit of every possible doubt, and that we craft law and procedure that ensures that the police, that law enforcement generally cannot intrude into our own affairs unless they have satisfied a very strict burden of proof. In this case, you have heard evidence that that was not followed. And the instruction in Section 11 is to ask you to decide certain key questions about the evidence that, if you find in that direction, would entitle you, in fact, would require you to disregard a significant amount of the evidence in this case. And frankly, that isn't a terribly onerous burden, because the overwhelming majority of the evidence that you have heard in this case has nothing to do about February 28th, 2019. It has nothing to do with the confrontation that happened in the blink of an eye. It has to do with after Andreen is already dead. The state wants you to suggest that that's consciousness of guilt, but what does that even mean as a term? What does that really imply legally? There are lots of reasons that people might make poor decisions in the wake of a tragedy like this. There are lots of reasons why people might panic and might try to cover things up. But that doesn't teach us anything about whether they are actually guilty or not guilty. The state is depending on you all to ignore that fact, because that's the only evidence that they can provide you. Whether you consider it, whether you don't, at the end of the day, I'm confident that you're going to reach a fair decision, the right decision in this case. But I think it's important that you understand that it may not be necessary for you to consider a significant amount of that evidence at all. You heard testimony in this case that on March 2nd, in the morning, Deputy Lozano went to Solitude Cove. He was instructed to go there. His unit works at the behest of the sheriff directly. He assists the sheriff's office in a wide array of tasks all around town. Very little of it seems to have much to do with fighting crime. They come all the way from the west side of San Antonio up to Stono to report at a compound, at an outpost that's been set up for the Andreen McDonald case. And they're instructed to go and do a community caretaking check over at Solitude Cove. What you all know is that the Bexar County Sheriff's Office thoroughly searched Solitude Cove the day before, extensively searched it, and had cleared the scene and had turned it back over to Andre McDonald. What you know is that that search was done pursuant to a search warrant. But they weren't satisfied with that. They wanted to see if they could get more evidence. They didn't have a good reason to. There was no new change of circumstance that would have authorized going to get a second warrant. So what do? They send Deputy Lozano. And the state is relying on the idea that because the garage door was damaged when Deputy Lozano arrived, that would make a reasonable person think that maybe there is something going on here, that maybe there's someone in trouble inside the house. But that's a ruse, folks. The Bexar County Sheriff's Office had everybody at its disposal working on this case. We know from the records of the gate codes that there was a Bexar County Sheriff's deputy inside the neighborhood where Solitude Cove is located at least 20 minutes before Andre McDonald returned home that morning, and certainly would have been there surveilling him when the garage door was damaged. They would have known that this was someone bumping into their garage, that it wasn't a burglary, that it wasn't some catastrophic event, which is how Deputy Lozano portrays it. Now, I'm not suggesting to you that Deputy Lozano is lying to you or that he's dishonest. I believe that he individually believed that there was something the matter. But we know that Deputy Lozano was sent there with an ulterior purpose in mind. We know that the Sheriff's Office at large was perfectly aware of the greater set of circumstances. That collective knowledge of law enforcement is something that you all need to consider when you're deciding whether the officer's decision to enter Andre's home was reasonable. enter his home without a warrant, unjustified. Our founding fathers thought that the privacy of your own home was the most sacred thing that the Constitution could protect. That barrier between you and the outside world, you and your government. If the government's going to cross that threshold, they have to get a warrant to do it. They circumvented that requirement in this case by sending an officer in his good faith out there to go and see, oh my God, there's this door damaged here. But we know that the sheriff's office already had that information. They knew why it had happened. They knew that there wasn't an emergency. You also heard testimony in this case that on March 1st, the day before, Carol Gambar believed that Andreen was dead when she saw the blood on that light switch. You've heard testimony from officers that they were treating it as a homicide investigation. You understand that they were treating this as a crime scene, not as a true missing persons case at that point. They weren't in there to go and help somebody. They knew that there wasn't anybody inside to help. They went in to go and find more evidence. And it was that intrusion by Deputy Lozano that finds the shovel in the back of the Porsche. And from there, all of the rest of the evidence that you've heard was obtained. Some of it by warrant, some of it without. But all using the information that Deputy Lozano had when he walked in to Solitude Cove that morning. The law asks you if you can determine from the facts and circumstances that that intrusion was unreasonable, that it was not objectively clear that there was anyone in need of assistance or help inside that residence, that you cannot consider any of that evidence in your deliberations. I am confident that you will reach that decision. I just want to briefly address a couple of other things before I let Mr. Convery take this home. Presumption of innocence is still in play. Presumption of innocence only disappears if you all are persuaded beyond a reasonable doubt that you can no longer adhere to it. The state has not met its burden in this case. What the state has to contend with is not how many implements of concealment and destruction did Andre McDonald purchase in the aftermath of this tragedy, or what steps did Andre take to avoid being caught in the aftermath of this tragedy. The question is, what was his legal culpability that night when they're fighting? You have several possibilities to consider. As Mr. Convery told you in his opening statement, this isn't a murder case. Andre may well have been reckless when he kicked Andreen, and you may find that he's guilty of manslaughter. Andre may well have been less than reckless, negligent or careless, in which case you may have to find him not guilty, no matter what. But you heard clear evidence that Andre also was acting to preserve his own safety and well-being, his own life, in an act of self-defense. You need to consider that for both the murder application, when you're deciding whether it's intentional, and the manslaughter. You also need to consider whether his actions were voluntary. You've heard evidence in this case that Andre would have been justified in using force when Andreen spit at him and got in his face. He would have been justified in using force when she charged him and swung at him. And in each of those instances, you have heard testimony that Andre responded with proportionate force. And yet we have a tragedy here. We have a dead body. One of the things you need to consider is that Andre may well have intended to kick Andreen, but he certainly did not intend to cause her death. You can consider that as a function of the mens rea for murder, the intention, whether it was intentional, but you can also consider whether it was a voluntary act at all. In other words, he may simply have not understood his own strength. He was reacting as he reasonably believed was proportional to the violence that was put upon him. I want to thank you all for your service. I know we've taken a ton of your time. It's been a great honor and privilege to represent Andre in front of you all. And I know that when you go back to deliberate, that you will reach a fair and just decision.
One second.
Commissioner. This is not a murder case. At the beginning of this trial, we told you that. We told you that we were going to be talking about Andre McDonald, the defendant, person on trial. And you heard an awful lot of background that perhaps in a lot of cases you wouldn't even hear. You know that Andre McDonald came from Jamaica. He went to school in Jamaica. He left after high school. That he joined his mother in Florida. That he put himself through college and had a part-time job in computers and IT. You know that he bought Andreen McDonald here to the United States, to Florida. That he sponsored her, that they married. That she went forward with her education, and that he paid for it, and that he helped her with it. And you know that their relationship was good. That he gets promoted, they move to San Antonio. Now, so there's nothing about that time period. We get to San Antonio 2010, something like that. They continue on. They start a business together. You heard about that business. You heard about he funded it. He's working on maintenance. That through the first test in the business, they lived upstairs. At some point in time, they bring Andreen's mother to live with them. And at all times after that, she's living with them. I think that's very significant in this case. Okay? And that in 2016, out of the blue, while he's away for temporary duty, Andre McDonald gets a text that don't come home. What the heck is going on? That he comes home, she convinces him through family and friends to get back together again. They move on, they're carrying on, the business is growing, they're both working, they're taking care together of a special needs child, an autistic child. Andre McDonald tells you how he taught the child to read, how they spend more time together. I don't dispute that Andreen McDonald interfaces with the teacher more. The fact is that Maureen spends a lot of time with the child and works shifts at the assisted living place. All this is a preface to reaching the time period where this man has no past, no bad past, no criminal activity, no disciplinary activity, nothing. And he reaches this point. Colonel Chetelack is a very telling witness, and he's not a defense witness. This is not someone the defense brought to you as part of the story. The state of Texas, the prosecutors, brought Colonel Chetelack to say he's a good officer. He's an experienced, dedicated, field-grade officer. No problems with him. He highly recommends him. We know that he has a top-secret security clearance, and we all have some perhaps general idea of what that means. He and Andreen get involved in this tragedy, and Andreen is killed. Andre has taken responsibility for what he's done throughout his life. Andre has taken responsibility for what he's done by calling and talking to his mother-in-law and his sister-in-law. I think that's very important. This case is not about the concealment. It's not about attempts to avoid responsibility. At the beginning of this case, we told you it was going to be about what kind of responsibility and what degree of responsibility. Came into this case knowing from the very beginning that he had called them and told them what happened. And I characterized it as what I think it is. I think the whole conversation was about remorse. I think the whole conversation was out, as his mother-in-law said, getting this off of his chest and not having them hear it in court. And I don't think that's disrespectful. I don't think that that's the type of avoidance that the state tells you he wants to continue doing. I think it's very telling. Now, the prosecution has manufactured a new charge in the state of Texas. They've just made it up. Domestic violence murder. I'd like each and every one of you to look at that charge that you've got. You won't find it. The legislature's never taken it up. There's no different punishments. It's not an offense. Okay. But it's part of this story that's really not true, of this idea that this is domestic violence, that Andre is somehow some kind of domestic violence abuser, and that it all led to him murdering her, as opposed to what it all actually led to. Any mature person knows about the emotion and the severity of feelings for someone that you love. That it's more than a stranger. It's a fact. With someone that you live with, that you share a home with, you share a child with. You don't have to ignore that when you sift through this evidence, as you do, because you're the judges, the exclusive judges of the credibility of the witnesses. So he's relying on you. Andre McDonald has put himself in your hands to determine what's appropriate in this case. And it's your individual judgment. Each one of you has to think, what do I think based on this framework of the presumption of innocence and the prosecution's heavy burden of proof and beyond a reasonable doubt? And within that, what do I think is just? What is right? You're not to be questioned on. It's just your decision to make when you go back and you deliberate. And in this time period that I have with you, I'm going to go through some things with you that we've all experienced in this last week. I want to start with July the 4th, 2018. First, I want to point out that 2016, a couple of years before, is when the text comes that's kind of strange about, that starts off issues in the marriage. That in 2017 is the divorce petition. These people are going to go into court and get a divorce. And Andreen talks him out of it. But at the same time, tries to dirty him up a little bit. The phone call about where the police come to their residence 2 times. This is not the repeated instances of some domestic abuse situation. They come 2 times, and the first time, the police leave after seeing that there's absolutely nothing wrong with Andreen McDonald. The second time, it's because Major Andre McDonald has called them the next day and said, hey, could you meet me at my house so I can get my things out of the house? That's not an abuser. That's somebody who's trying to do the right thing. And in a divorce setting, it's somebody who's trying to make it look like it's him. The 4th of July, Brownsville, Texas. The marriage has had trouble for the past year. Albany in Jamaica. The trip to Brownsville. The big argument. A big event in this marriage. That tattoo of Andreen's, the infinity sign with the A in the middle, is new, and it's on her hand, and he sees it. That's her lover in Jamaica, who Andre McDonald knows to be a thug drug dealer. Oh my gosh. Oh my goodness. Cause for an argument, any domestic violence, any hitting, beating. This is the event after 4 hours on the way homeward when she won't let him out of the car. He scratches her. That's what her father, Paul Anderson, and he are talking about. Well, that's not a big record of domestic abuse. Let me out of the car. let me out of the car, let me out of the car, I want to walk, let me out of the car. And look, you don't have to rely on me when you go back there. There's the tattoo, right on his chest. Din Din's birthday celebration is coming up. He knows that at this time. He knows that his wife, Andreen McDonald, has marked herself, has tattooed herself with a thug drug dealer's birthday. Reason to get angry? Reason to be upset? This is the 4th of July, 2018. Domestic violence? No, not really. They decide to try to work it out. Marriage is not good. They have a business that's growing. Heck, by the time it gets to February the 28th, they're working on their 4th assisted living, mortgages, construction, business plans that he does. There are two people who are working, waking up every morning, taking care of a special needs child, and doing the best they can. It's simply unfair and wrong on this evidence to say that Andre McDonald has some issue or problem with abuse, domestic violence. Elena's Property Management, LLC, is formed on 7/10/2018. So who's plotting and scheming about assets? He doesn't know anything about that. That's what the H&R Block issue is about, where he's to come and sign his taxes. He goes there, and we'll talk about that. For Andreen, this marriage is over. She's hatched a plan to go to Jamaica. Wants to take the business assets for herself. I think that's pretty clear. But if Andre leaves her first, her plan can't work. That's what there is as we go into February the 28th. When Andre at the H&R Block realizes Andreen's been siphoning off assets into a new company held exclusively in her name. Andreen is furious, stern. They talk to each other in patois in front of Ms. Brockman. And Ms. Brockman, another staged witness, tells you that just the year before that Andreen had wanted her not to share things with Andre. And she told him, no, I can't even do that. What I call the Fagley, I think it is video. Person who took the various videos and phone records and things and put them together in State's Exhibit 174. It's very important because when they go back from H&R Block, they're arguing. They're arguing. No question about that. But Andre, at all times in this video, goes out of his way to avoid a confrontation. This is not someone who's about to intentionally, knowingly murder someone. Andreen keeps the argument going. Andreen texts him. He's at that Shell station. What's he doing? He's cooling off. He's cooling down. He doesn't want to continue any kind of fight with Andreen. I think that's pretty apparent. And as members of the community, you can look at those texts, and these are not people, there's not a lot of outrage in these texts. When the state gets up and calls this an argument, it is. But it's a pretty darn polite argument in writing. There's no cursing. There's no nastiness, no ugly words. There's just, this is a community. Property, state. Andre's text, there's no way on earth that company form is going to earn anything. He calls the Broadway bank account incident, which was her not putting him on certain accounts. And after what you did last year, you must be crazy. Do not represent my interests. All you do is scheme, and I'm no fool. Andreen, there's nothing I can own on my own, you idiot. Notice how Andreen's text provoked the argument. Then why did you register it in just your name? It continues on. Andreen's text, Andre's return. We get to the point where Andre doesn't go home. This is a really important thing I want you to know. He doesn't go right home. He goes to the park for 4 hours between the Shell station and the house and just tries to calm this down. He's expecting to go home. Andreen wants to appear in Auburn's old news. We know from Carol Gambart, Maureen Smith, Andreen is still seeing Auburn. She just got home from Jamaica. She's furious Andre won't go back for this concert. Neither of them are interested in it. Andre simply didn't take that bait. And he went to a park, and he calmed down, and he went home. Andreen, I don't care if you file for divorce. It's midnight. Andre stays at the park until midnight. He's trying to cool this argument down. You know what the gate code is. She stews the entire time he's gone. He comes in and he finds somebody at midnight. You'd expect somebody who's getting up at 5 a.m. to be asleep. No. She doesn't back away or stop any confrontation. She doesn't drive away in either of the cars. Why isn't this fair? It's not disrespectful to the deceased to ask these questions in this circumstance. She didn't go to bed upstairs and wait for the morning. When he comes back, she's looking for a fight. This terrible Jamaican curse, go suck your mother, Bobby boy. In English, go suck on your mother, you homosexual guy. Which has been explained as a terrible, terrible curse. And whose mother are you talking about? He says, my mother's been nothing but good to you. Your mother. Your mother. We're going to get a divorce. He says, I'm going to keep my job. We're each going to get 50% of the business. You can go your own way. It's Andreen who isn't finished. Andreen charges after him in the bedroom, screaming the same thing. He tells her, get out of my face. He's done everything to avoid confrontation. She's taunting him. What are you going to do about it? What are you going to do about it? He tells her, you're going to get me in trouble. She moves closer still, spits in his face. Spitting in someone's face is an assault. If I get up close to you and spit in your face, it's an assault. And how does he respond? He goes to grab her face, her forward momentum, they come together, they're turning that into a headbutt. The prosecution's calling it a headbutt. What it was is they came together, and she's got a small abrasion or a cut on her. She goes into the bathroom, there's blood on her face, turns on the light. Andre's about at the doorway. She's furious. She charges Andre. This woman who's taller than him, probably stronger than him, who can lift 285 pounds and carry him around the house in a piggyback ride like it's just not much of an effort. Assault and self-defense. Andre was assaulted. He has the right to use proportionate force. He uses her forward momentum against her, trips on the floor, she's charging him, kicks her twice as she goes to the ground. The pitter-patter of little feet. Andreen wheezes. He hears Elena. They go to Elena, gets her back to sleep. Panic. Everything after that point. He goes up and puts his child to sleep. Imagine, and comes downstairs and she's dead. She's asphyxiated, which is exactly what the autopsy, what the experts say. Her hyoid bone is missing. Look at the autopsy report. They can't rule out asphyxiation. And you know from the evidence that there's not any instruments, there's not any tools, there's nothing else that happened in that house but this. She is dead. He panics. Get the body out of the house. Take the body to Speck Road. That time he's just says, I'm just a robot. Some people internalize some things. Grief, panic, sorrow, and other people externalize. He internalizes things. He sits in a police car the next day for 12 hours and he's furious. He's furious. You still, after 4 years, detect some of that. I'll agree. Because he believes that he was put in this circumstance and he's not responsible in the way that the state is claiming. He wasn't wrong then and he was not wrong now. Hey, there was a body. I'm going to get blamed for it. That's the end. I'm going to lose everything. I'm going to lose my career. I'm going to lose my daughter. I'm going to lose my... It doesn't matter. It's not... Andreen's deceased. If he tampers with evidence, look in the charge. You're not here to decide tampering with evidence. If he disrespected the corpse, if he abused the corpse that the prosecution is going to dwell on, that's not in front of you. It's for another day, if you will. You're looking at whether he committed murder or manslaughter or if there was self-defense involved. Lights the body on fire, hits the body with the hammer. All of it's consistent with the autopsy report. Consciousness of guilt. Conscious of what? Guilty of what? He's in turmoil. He's charged with a felony with tampering with evidence. And you know what he does? He doesn't say anything. When he's told you have the right to remain silent, he exercises it. Until we get here. It's just that simple. He doesn't put posters up. He doesn't, where's Andreen? He's not actively doing a single thing. Is it bad? Yes. It's bad. Is it murder? No. It's not. You're the people who have to look at the degree and the level of responsibility. But Andre McDonald has already told you what he did, and he decided, I'm going to tell what happened in court. I'm going to tell my mother-in-law and my sister-in-law to begin the process of healing, to begin the process of closure. And you know what's really, really important about that? They believe it. You can tell from the testimony of Maureen Smith and Cindy Johnson that there's love involved in this family, that there are relationships involved in this family, that there's care and concern. They don't come in here and snarl and talk about how they hate him and poor Andreen. Carol Gambar said it best. Carol Gambar, while she's listening to her talk to her thug drug dealer lover on the phone, just before this, tells her, you're playing with fire. Girl, you're playing with fire. Either you're going to kill him or he's going to kill you. Now, why would a good friend say, you're going to kill him? Is it that unusual or that outrageous in this fact situation to think that they want to lure him down to Jamaica and get rid of him? Because the whole effort in the troubled marriage has been to get all the money.
Yeah,
the assets.
10 minutes. 10.
And that's a 41-minute phone call, an emotional phone call between the people. Even Paul Anderson, these people, he's so straightforward. I wanted them to get counseling. He told me that he scratched her because he was angry. That's all true, but that's all that is. Andre McDonald did not intentionally or knowingly murder Andreen McDonald. Whether he was reckless is for you to decide. At best, but he acted in self-defense. And when you look at this charge, even if you believe it's murder, you have to look at self-defense. That's when to look at self-defense. If you believe it's manslaughter, you still have to look at self-defense. If it's something that you don't have in front of you, then your duty and your obligation is to say, not guilty. Whatever determination you come to, it's yours. You're the justice, not the prosecution, not Andre, not Andreen. You, each and every one of you, have to do what you think is justice. And I'll tell you what, when you're all done, it's still going to be a tragedy. A terrible, terrible tragedy. Thank you.
Thank you, counsel. State you have 32 minutes.
Thank you.
Folks, before I get into the crux of my argument, I want to address a couple things that defense counsel brought up. I believe it's section 11, that's the part that defense counsel referenced in terms of Deputy Lozano going into the house. That's when they saw the garage door broken, went in, they saw the shovel. So I want to talk about that for a little bit now. If the defense wants to convince you that the Bexar County Sheriff's Office had this grand conspiracy, trying to concoct a reason to conduct a search on the house, that nothing had changed between that March 1st date and the March 2nd. We know that's not true. We know that's not true for a few different reasons. This man had been unaccounted for. Nobody had eyes on him for about 12 hours. They left that house early morning hours of March 2nd after they were done with that search, probably around 1-ish or so in the morning. And then nobody accounts for him until about 12 hours later. We also know that that garage door was perfectly...
That's a misstatement of the facts and evidence.
Okay, the jury will call the testimony. Can you speak a little louder, Mr. Street?
Of course. We also know that that garage door is now damaged. We know that we have a missing woman, and we know that he has now left that residence on the way to what we know later is to buy a gun. The situation had clearly changed. You had that instruction about the emergency doctrine within the charge. Of course, we would want a situation, something like that, we don't know if this person is hurt, if they're dying, what is wrong, this garage door is damaged, and this guy just took off. But we want to try to say, oh no, the police can't check. They can't try to make sure that anybody is okay. Then on the second part, they're trying to say, oh, this is some type of improper search. What did they see? All they saw was that shovel in the back of the Porsche. You heard that when they went inside that house, they were calling out for Andreen. They were calling out to see if anybody was hurt. Did they search anything? No. You heard Deputy Lozano say on this stand, a deputy who had been, I believe, close to 30 years experience, said that once that had ended, we left and we got a search warrant.
This is an improper argument. The fruit of the poisonous tree entitles this jury to disregard all of the evidence seized as the consequence of both searches on March 2nd and all of the subsequent ones. The jury is entitled to make that finding.
Okay, they got the instructions and don't they follow that. It's denied. Right?
The reason defense wants this is clear. They want you to forget and disregard about all his actions after that case. They want you to forget about that, about all the evidence that he hid, the lies that he told, and the deceit. Way back at the beginning of this trial, defense counsel said that this is a case about responsibility. They try to claim that this is self-defense. Folks, this is not self-defense. This is a cover-up. He took the stand on Monday, and he admitted he lied to everyone. He lied to his friends, the police, Lieutenant Colonel Chatelain, everyone about what he had done. He also admitted that he tried to hide evidence, and he destroyed evidence. He burned clothes. He tried to burn her. He hid the hammer. He had clothing, the flashlight. During this trial, when I asked him on Monday about what these witnesses had sworn in their testimony and told you, he said, well, they're lying too. When I asked him about Deputy Gonzalez, for example, about what he told him, well, no, I didn't tell him that. He's just making something up. When I asked, how about when Carol Gambar, when she said that she told you, we've already been at the house, she's not there, in response to his comment, well, maybe she has some type of a migraine, maybe she's at the house. Well, he said that was a lie too. Now, despite all of this, despite all of these lies, he's coming to you and saying, no, believe me now. Now I'm telling the truth. What I told you Monday is what really happened. Let's look at a few of the undisputed facts. We know they had marital difficulties. We know that they had a verbal argument at H&R Block in front of Juanita Brockman. We also know that that argument continued when they went to Solitude Cove. We know that the defendant at some point left and went to that Shell gas station, the video that you had there. And that argument continued during those text messages between the two. We know at some point he returns to Solitude Cove. Now, he wants you to believe that Andreen is the aggressor. He wants you to believe that Andreen is picking a fight. She's itching to have a fight with him. Well, let's look at a few of the responses that she has in those text messages to him. He made sure that she can't be here today to tell you what she was thinking. But we have
shifting the burden.
It's overall.
But we have unique insight into what she was thinking and saying because of these text messages. Let's just look at them. I'm really tired of arguing. I cannot do this every week. If you refuse to move on, then I really don't know anymore. I prefer to try to be silent because everything that I say is offensive. Well, if you don't let it go, next time we go our separate ways. Have a good night. Are these the words of somebody who's trying to pick a fight? His response right after that last one, have a good night, is a derogatory response to her. Go back and look at those messages. This is not a woman who's trying to be engaged in some type of conflict. This is a woman who wants to end it and stop it and not argue. You also heard from her dad, Paul Anderson, on Monday. He talked to her February 28th, the last time he ever got to talk to his daughter. What did he say? She was crying on the phone. You heard Mr. Anderson say that he has heard her cry twice in her adult life. Once when she lost her brother in a motor vehicle accident about 10 years before that, and that night. These simply are not the words, not the actions of somebody who's trying to pick a fight, somebody who's trying to get in some type of altercation with that man. But we know, both from the evidence, from the text messages, and from his testimony, his mindset. I made her. She owes me. She's disrespecting me. She's stealing from me. It's her fault this is happening to me. She's trying to set me up. And folks, even furthermore, when he testified on Monday, these are direct quotes from him, word for word, what he said. Why me? Why me? Why the hell does this shit have to happen to me of all people? I was just mad at the person that I believed had caused this whole situation and destroyed all of our lives. I'm just pissed off at Andre. I was angry as hell. These are the words from a man who wants to fight. These are the words of a man who wants to teach her a lesson. These are the words of a man who wants to do her harm. He then gives this story, this self-serving story, saying that despite the fact she is so strong that he murders her using just her weight to knock her down and 2 kicks. Does that make any sense at all? Meanwhile, this person who's so powerful, who's so strong, what interest does he have on it? Nothing. If she's really as powerful as he's trying to claim that she is, and that that's all that happened in that bathroom, don't you think she would have at least scratched him, done something to him? Sorry, I'm not sure what happened. I apologize. We also know, when I asked him, that he never once thought about trying to get her any help. It didn't even cross his mind. We also know from his story, this is the last night, the last day, that little girl ever sees her mother alive. All of his actions at that point, none of them are about a man who's trying to take responsibility. He says he puts her in trash bags and drops her in his car. How did he describe that on Monday? It was a hassle. That's what he said. It was a hassle. He intentionally leaves his cell phone at the house so he cannot be tracked. He drags her body out to a field, strips her naked, and leaves her there. He sends these cover-up texts, one at 1:50 and then one short at 1:52, trying to hide what he had just done. He burns her clothes when he gets back to the house. He wipes down the bathroom. He destroys her phone and disposes of that and any of the remaining clothes. He also lies to his daughter that night. He also lies to his daughter that night. He tells her that Mommy fell. He did leave a few things. Blood on the light switch, the blood on the door, and the burn rod. His lack of taking any responsibility continues. He lies again to his daughter that next morning, said that she's gone, that she went to her workout. He lies to Carol Ann when she's finally able to get a hold of him about, she's at work. Oh, maybe she's at home with a migraine. When Carol Ann says, no, that's not true, we were just there, what does he do? Click. Turns off the phone and gets his butt up to Solitude Cove as fast as he can to dispose of more evidence. He lies to Maureen about where she is. He has this farce about trying to go to the hospital to pretend that she's there. Then he lies to the police. We know after the police finish their search, he goes back out that night. We have the records from the gates. We also now have his testimony. He goes out there, and what does he do? He covers his wife, his daughter's mother, gasoline, and he sets it on fire. We also know that he then goes and tries to dispose and hide more evidence. The hammer, the flashlight, and clothes, including her clothes. Later that morning, he goes to Lowe's. He buys an axe, a hatchet. He buys contractor work bags. He buys gloves. And he buys 2 5-gallon gas containers, which he fills up. We know he was out there because he was going to dispose of her body by cutting it up. Now he tries to claim that he had some crisis of conscience. That's why he didn't do it. We know that's not true. We know he didn't get the opportunity because the Bear County Sheriff's Office got to those items before he had a chance. He also goes and purchases a gun. This is a man who's only concerned about himself. He constantly blames his wife for everything he did to her. You heard his testimony. I think he referred to her as Andreen maybe once or twice. He continues to depersonalize her using terms like her or the body. Won't even refer to her as his wife. You saw that testimony on Monday. Did he show any remorse? Did he show any emotion? His actions are clearly cold and calculated. The only thing he's sorry about, he got caught. That's his only concern. How things would affect him. 133 days. That's how long Elena, Maureen, Cindy, family, and friends suffered
You know,
not knowing.
I object. The defendant has an absolute right to remain silent and exercise that right. This is a comment on the defendant's exercise of a constitutional right.
Okay, also saying that I didn't hear the rest of what he said, but also saying any comment on him being quiet.
I would just ask that the court instruct the jury that they can't consider the defendant's silence during this period
Okay.
for any reason.
The jury would disregard that last comment, not consider it for any purposes.
Motion for mistrial.
Not.
133 days. They did not know where she is. They did not know what happened to her. Hundreds of people searched.
You have 10 minutes.
Thousands, thank you, Judge. Thousands of hours were spent trying to find this woman.
I'm sorry. My math is bad. You got more than 10. I'll give you the 10-minute warning.
No.
Go ahead.
Thank you, Judge. But for Clifton Kilbunday, just happening to go out there to try to retrieve a cow skull in mid-July, we might still be searching. But thankfully, he came upon this. Now we know, and you heard this testimony on the first day of trial, that he called Cindy in an effort to try to reach Maureen to tell what he said happened. And what did he tell Maureen and Cindy? They both testified to this, that he used the term stomped on Andreen, that he stomped on her. He also told both of them that Andreen could not fight him because he was too strong. He also said that Andre never physically touched him. Both of those women testified to that. The defendant also said that that was the last time that Elena saw her mother dying. But now, he's saying that both lying what he did yesterday or on Monday. And why is that? Well, he had to alter his confession. He had the benefit of sitting through this trial and seeing how things played out. And seeing the multiple inconvenient and damning facts against
Your
him.
Honor, this shifts the burden again. The presumption of innocence is on the defendant. It's the state's burden to prove this beyond a reasonable doubt. The way that they're phrasing this is trying to put that back on us by just simply, Andre McDonald isn't here because he wants to be.
That's denied.
Being made.
You heard those facts. You heard that testimony. He now has to alter what he told you on Monday based upon that. Because he had just another attempt to cover up his actions in this case. He's lied to you at every single step. Why would we think he's now telling the truth? Let's compare the two. Instead of saying, Andre can't fight me because I'm too strong, now he's trying to paint her out as some type of superwoman. Instead of saying, Andre never physically touched me, now he's saying, oh, she rushed me and she started throwing punches. Instead of throwing or pushing Andre to the ground, he's saying, oh, I used her own momentum to trip her and knock her down. And instead of repeatedly stomping on Andre, now he's saying, I kicked her twice. Did that cause her to die? We also have the unique ability to look inside the mind of a murderer from those messages that he had on that second cell phone, the ones that we presented to you this past Monday. How long does DNA last outdoors? Do you always leave fingerprints? Does fire destroy fingerprints? How long does it take for an unburied body to decompose? Do maggots eat cooked meat? Through these hundreds of searches that he has pertaining to this case, not once does he ever search self-defense. Folks, it is time for responsibility. It is time for justice for Andre. It's time for justice for her daughter. It's time to hold this man responsible for what he did. And it's time to find him guilty of murder. Thank you.
Okay, thank you, counsel. Okay, ladies and gentlemen, you have all the law and evidence before you. You can go ahead and recess to pick your foreperson and begin your deliberations. As far as the two alternates, the deputies, you guys are excused. I think you're in the corner. I want to thank you for your service. I know you've been here for a while, away from loved ones and family and friends and work. So thank you. You're excused from here, so it'll be only the 12 jurors that are on the panel to deliberate. And lunch should already be here for y'all. Thank you.
All rise for the jury.
newspapers, social media, talk to loved ones about the case. And I'm not sure if any of you have already got each other's numbers. Don't be conferring about the case until all 12 of you are together tomorrow morning. So let's do 9:15, and you'll meet in the back jury room. You don't need to come in here. We cannot start deliberating tomorrow morning until all 12 of you are in there. Okay, so if a couple of you are running late, you just got to wait till you get started. Talk about other stuff, but not about the case until that time. Okay?
All rise, the jury.